Time to check in with our CJAD 800 legal contributor. That is Chris Dimakos. And Chris, here we are 4 years after the pandemic, but we've just had a court decision here relating to the pandemic. And this is something we spoke about, I guess, at the time, this idea of companies mandating their employees to get vaccines. In this case, we're talking about Canada Post. We know that for those who didn't at the time or would not necessarily prove that they did, there were people who lost their jobs. Well, this thing went to court. What happened?
Yeah, so they took a look at all the different arguments, and the employees that were unionized filed grievances, obviously, and they said, hey, we were remote workers, and we didn't want to get vaccinated, and we were not a danger to anyone in the workplace by Canada Post forcing remote workers to get vaccinated, and if they didn't, basically suspending them without pay, that was a violation of their rights. And when the tribunal said, in that instance, whenever you have a policy, a workplace safety policy, it has to correlate to your objective. So, for example, if you're going to implement measures, you got to make sure that they're trying to achieve the objective you're setting. So, in this case, you wanted the vaccinations to protect people in the workplace. If people are working exclusively from home, that measure of forcing them to get vaccinated, there was no correlation, not enough anyways, for them to say that they merited to be suspended. So, in that case, the employees were successful in making a claim. But on the other hand, there was another claim that they made. And for the employees that were working in the office, they said, I don't want to get vaccinated, but I want to work remote. I can do my job remote. Why doesn't the employer allow me to work remote instead of being forced to get the vaccines? And in this case, the court said it's within the management's right to decide where you work. So no, you cannot force your employer to have you work from home because you don't want to get vaccinated. And that's a big one. And the reason why is there's so much discussion about whether an employer can force you to come back to work. And this decision says that they can, and they have the right to decide where you work and where the work's conducted. So it's an important judgment, obviously, because it sets a precedent, which is always important. But we're starting to see now that the more and more there's challenges coming down, and we're seeing a fine line between when the employer has you in the office, they have a lot more control over what gets done and how it gets done than, let's say, a remote worker where they don't have as much. So that's the message from this case.
Okay, so it's kind of a win and a loss at the same time in this case for Canada Post, right? I wonder, though, when there's a decision this way, we always talk about precedent in the legal system. What about private companies, who have employees who were basically faced with the same sort of reaction or decision by their employers? Do they take this as jurisprudence and move forward?
Right. So there's always differences between these public corporations and the private ones, but the essence here is, does the employer have the right to decide where you conduct your work? And unless there is a human rights issue, and the court talked about this, if there is not a human rights issue involved or something serious where the employer should accommodate, if it's just a question of, hey, I don't want to get vaccinated, so I'm gonna work from home, that's not within the employee's right. And that's the message that can apply to both private and public corporations. But there's no question that there's many of these judgments. And when you're a lawyer, you kind of pick the ones that you like and you try and disregard the ones that you don't. And so that a lot of that's going to be happening over the next couple of years. And when we're going to be talking in 2028, we're going to have a much better idea of where that line is drawn and concerned.
Did you say 2028?
Yeah, absolutely.
2020, that's 4 years from now.
Right. Well, we talked about this 4 years ago also.
Oh, I see. Okay.
Right.
Hard to believe we'd still be doing this. So, I mean, I understand the court system moves slowly in this country, but, for this to now happen, it's kind of mind-boggling in a sense. So
it is extremely slow. There's no question about it.
Let me get to another story here. We have often talked, again, about things like NDAs, non-disclosure agreements, but typically from the perspective of employer-employee. Then I come across this story where we have Canadian banks, and the story was about Toronto Dominion or TD Canada Trust, but other banks apparently have been involved in this as well, where they're asking people to sign NDAs over something the bank actually did wrong. In this case, someone was charged a fee for something he had been told there would be no fee for. When he complained, first they said, sorry, can't help you. Then they changed their mind and said, we'll give you your money back. We'll acknowledge our mistake, but only if you sign an NDA, which this person refused because he had done nothing wrong. What was the need to sign an NDA? So are we starting to see more and more of this? And what are your rights as a customer, a consumer here, to simply walk away but still be able to get your money back?
Right. So two things. NDAs are extremely common. And I know I read that very same article, and there's talk about whether or not they should be used or not, but they are used almost always. I've very seldomly been a part of a transaction where we didn't have these types of information. And the reason is it's not just about the fees, but if the bank wants to buy your silence, there has to be consideration for that. So, people are listening and talking about, should I sign? Should I not sign? It's a private transaction, and if the bank or any party for that matter wants to buy your silence, well, then the key word there is buy. There has to be consideration for it. If there's not, if they're just restoring fees that they took from you and it was their fault, and they're acknowledging it's their fault, having you not talk about it with no consideration at all, obviously I would not recommend that. But it's very common to have non-disclosure agreements and just clauses of confidentiality. Even when you get the packages, when you're an employee and you get terminated, a lot of times employers don't want you talking about how much they're giving you, so they make you sign a contract in a transaction that has that language in there. But again, there always has to be consideration for that. So if you are involved in any type of deal where someone is asking for your silence, you have to be able to identify what part of that package, what compensation is there to buy my silence. Because if there is none, well, then I wouldn't be so inclined to sign one. There has to be some consideration for that, because in essence, they're doing themselves a favor. They're buying, they should be anyways, the silence to protect their goodwill and protect their brand. Well, that's worth something, and you should be compensated accordingly.
Well, it almost sounds to me, I mean, the bank, basically, as you're describing it, is buying your silence here. The more they give you, the more likely you are to say, okay, I'll go ahead and say nothing. That just in and of itself seems wrong.
It does, but again, there are times, I tell this to my clients, there are times where, you want to do things for the good of everyone, and there are times where it's okay to be a little selfish. And sometimes when the bank makes a mistake and they're willing to compensate you for that, it's okay to be a little selfish. They are selfish enough. They make enough money. You can get some in return once in a while.
Okay. So in this case, and by the way, he did not sign the NDA. Others have now started a group because they were in the same position. Where does this end up, by the way? Do you think the bank simply says, okay, here's some extra dough, go away, or does this go to court?
No, I don't think it goes to court. I think the banks are just going to have an internal discussion and memo about when they should bring it up and when they shouldn't bring up. This thing here is about, I think it's $1.50 user fee.
Yeah.
They're okay with this. When it's a little more severe and the cost of this going public is much more substantial, we're definitely going to see that type of language in the agreements.
Okay. Interesting story. All right, Chris, thank you so much. Appreciate it.
Thanks, Aaron.